What? What? Okay, guys, I can't figure out what I'm doing wrong. Okay, here we go. Oh, oopsies. Forgot to take these off. Hey, y'all. Welcome, welcome to Legally Live. I'm your host, McKinley Molassong. Who do we have here? Looks like we have a few people. I see Flash, of course. Hi, Flash. And like, can y'all hear me and everything? Everything's fine, right? Right. My hair looks crazy. I do see that. And we have Nima. And we have Salty Dog. Wait, where'd you go? Hey. Man, I'm having a hard time. There we go. Salty Dog. Let's see here. All the things. Y'all know I have such a hard time navigating. Okay. I kind of want to put this over here. Okay, who else do we have in here? So today, what are we going to do? Oh, and we have Kathy. Hi, Kathy. Thank you for letting me know you can hear me. And looks like I got some of my drink on my face. Reminds me to take a little drink. Okay, so today I thought that we could go over the new filings. They're not new. They're new to us because we have not gone over the filings. I did look at some more of the emails, but I will say that after reading the new filings, it appears to me that like we're so brilliant. We have actually already covered all of the important emails, at least the emails that Murdaugh's attorneys found important, right? And we went over those like a while ago. So I kind of stopped reading through them because they're very boring. I don't know if y'all have looked at like the entire document. Today, what I did do though is I went through and put in just like I did a search for Jim Griffin, or actually, unfortunately, I put in a search for Griffin. I should have put in Jim Griffin because there's another person that works for Colleton County with the last name Griffin. And so I got 303 results, which is crazy. It was a lot. But the reason that I did that is because I wanted to see like if Becky sent because in her book, she claims that she was sent. So we obviously know she was sent information from the public about strategy, right? But it was the only evidence that I have of that is from the emails, and it was about strategy pertaining to the state's case, right? And she forwarded those emails on to the state, which is a big problem. But she also said in her book that she got emails concerning the defense's strategy as well. And so I just like wanted to see if she had forwarded any emails to the defense. And it is a Cajun name, Kathy. It's Meancon. But yes, it's Cajun for sure. And it has like a little, I don't even know what it's called, but is it like Sadia? No, it's not Sadia. Where am I getting that? I don't know. But underneath the C, there's like supposed to be a little mark there that I have never put there, but it goes there. Sorry, I should have brought that up. But yes, my last name is Cajun. But anyway, I have not found yet where she forwarded anything to the defense. Big shocker, I know. I don't think she was trying to help the defense's case. I think, everyone, and is it an accent mark? I don't know. Maybe. Oh, yeah? Does the Cajun that you're married to have a temper? Is this something I hear about Cajuns all the time? And like, really, all I have to go off of is, myself. but I mean, and my family. But yeah, I always hear like Cajuns have such tempers, and I do. Oh, really? Well, that's good. That is good. I don't know where I get it from. I hope I'm getting better with age, really. So anyway, yeah, so we're not gonna probably go through that much email stuff. We might like go back and look at some of my previous notes on this case regarding the emails because there were some emails that we just haven't gone over yet that I had written notes about, but I really don't think that they're actually that important now. Also, I did kind of want to correct some things. I know there's plenty of things that I should probably go back and correct if I like had all the energy to go back and watch my previous videos on this case, but, like, obviously, as I'm reading through, I'm figuring out more things about the case, and so, I'm realizing, like, some of the things that I said previously were not true, that I had just, like, said, like, "Oh, maybe this has to do with this," but anyway, I did want to make it clear though that I know the very first live stream that I did on this case, I was just like like I had not looked at any of the emails before, and I was just going through them with you guys and trying to figure out what was going on. And I know that I got confused. I saw where Becky was sending emails out to the media regarding that jury questionnaire. And then I saw in other emails after that where she was corresponding with Colleton County, like with their the clerk's office and with the AG's office and with Holly from Dick Carpootlian's office. And in those emails, she was actually including the juror information. So, like the responses that they got from the questionnaires, because she was sending them in batches, because there were so many responses that it required sending in more than one batch. And for some reason, at that time in the day, after I had been streaming all day, I got it confused and thought she was sending that to the media. I went back and looked, and it doesn't appear that she sent the actual juror information to the media. It looks like she just sent them the juror questionnaire, which the judge apparently told her that was okay to send. I have never really heard of it being an issue to send a blank juror questionnaire. And I know somebody actually in that chat had said that, and I was like, no, that's not what happened. But whoever said that in the chat, you were correct. I don't know if you're here today, but if you are, I'm sorry. I didn't know what I was talking about. It happens. So let's go ahead and see if we can. Okay. I need to pull this up. Let's pull it up. Okay. Actually, okay. I'm going to try to pull up this filing. So it was called, what was it called, you guys? It was called prehearing. Yeah, prehearing brief. So this was filed by Alec Murdaugh and his attorneys, and it is, oh, I guess I should share it with y'all. That might help, huh? Okay. Nope, we don't need you over here. Thank you very much. Okay. Oh, well, Flash, it depends on which emails you're talking about, like which one's being proper. It's definitely not proper for her to be sending emails to the state regarding their case strategy, right? It's not proper for her to be doing that at all. She's not a member of the AG's office. She's not a member of the prosecution, and she should not have been doing that. And I think if you look ethically at, which I think is like a whole different question, really. I mean, a different question than what they're going to be looking for in this hearing necessarily, but regarding whether or not it was proper for her to be sending emails during the time that she was getting paid to be court of clerk, if it was proper for her to be sending emails and working on her book at that time, yeah, I don't think that that's proper, but I'm not sure that that's actually at issue here. Okay, so this was filed in the I'm gonna skip over parts of it, I'm sure. It's 21 pages, and, um, it's a lot of words, and y'all know me and words. I'm not the best reader, so we'll see. Okay, so it was, filed in Colleton County, um, and it says, "Defendant's pre-hearing brief regarding motion for a new trial, Richard Alexander Murdaugh." This is not his appeal. This is regarding his motion for new trial. It is the pre-hearing brief. So it's to bring the new judge, because a new judge was appointed to hear this, to deal with the motion for new trial. And that is Judge Toll, I believe is her name. And so this is kind of to bring her up to speed on where the case stands right now and going like what they're going to be dealing with at this hearing. So it says defendant Richard Alexander Murdaugh through undersigned counsel hereby submits this pre-hearing brief as the court requested at the December 21st, 2023 telephonic status conference. So I think Judge Toll actually asked them to submit this brief. Introduction. Mr. Murdaugh was indicted for the murder of his wife, Maggie, and son, Paul, on June 14th, 2022. His murder trial began January 23rd, 2023. The presiding judge was the Honorable Clifton Newman. The trial ran for 6 weeks, ending with convictions on the evening of March 2nd, 2023, and sentencing on March 3rd, 2023. On October 27th, 2023, Mr. Murdaugh filed a motion for a new trial based on after discovered evidence, having obtained leave from the Court of Appeals to suspend his appeal of his convictions to file the motion. His motion alleges that Rebecca Hill, the elected clerk of court for Colleton County, had extensive private communications with members of the jury during trial. This allegation was supported by sworn affidavits of jurors and a witness to juror interviews, testimony at in-camera proceedings, and other evidence, including Mrs. Hill's own book, or Miss Hill's own book. The subject matter of Miss Hill's alleged communications was the evidence being presented by the defense at trial. I'm sorry, Brandon. Yeah, I posted in the Discord to tell people how to come here. But hey, you apparently got it. So that's really all I was trying to do. I don't know how to work Discord yet. Like, we're very lucky I even put a post there. But hello, let's go. Okay, so the subject matter of Miss Hill's alleged communications was the evidence being presented by the defense at trial. Mr. Murdaugh alleges that an elected... Okay, good. An elected state official deliberately violated his constitutional right to a fair trial before an impartial jury. If that allegation is proven, the law requires a new trial. Argument. Mr. Murdaugh does not need to show actual bias on the part of any juror. Hey, Dave. Hey. To obtain a new trial. If Mr. Murdaugh proves his allegation that Miss Hill communicated with the jury about the evidence presented by the defense during his murder trial, South Carolina and federal law require that Mr. Murdaugh receive a new trial, irrespective of whether the court believes the outcome of the trial would have been the same had Miss Hill's jury tampering not occurred. A defendant in a criminal prosecution is constitutionally guaranteed a fair trial by an impartial jury. Yeah, I am trying to read. Okay. And in order to fully safeguard this protection, it is required that the jury render its verdict free from outside influence. I'm not going to cite the cases here, y'all. Where there was the private communication of the court official to members of the jury, an occurrence which cannot be tolerated if the sanctity of the jury system is to be maintained, a new trial must be granted unless it clearly appears that the subject matter of the communication was harmless and could not have affected the verdict. The law requires the subject matter of the communication to be harmless, clearly harmless. Otherwise, a new trial must be granted. Asking the jury what it wants for lunch is clearly harmless. Telling it not to believe the defendant when he testifies is not. The issue before the court is a structural issue in Mr. Murdaugh's trial, not a failure to impanel unbiased jurors. Where a new trial is sought based on biases jurors brought with them into the trial, the required standard is to show actual bias, whether those biases were facts jurors concealed during voir dire, were created by state action during voir dire, resulted from jurors reading newspapers or other unauthorized materials during trial, or from initiating inappropriate communications during trial, or the like. The present case is different. Here, a state official argued the merits of the evidence presented to jurors during trial outside of the presence of the court, the defendant, and his counsel, and in other ways deliberately and surreptitiously used her official authority to direct the verdict to her preferred outcome. This is fortunately a vanishingly rare, but it is one that requires a new trial. Oh, event. I left out event. That's why it didn't make sense. Yeah, this is true. I don't have shots. Did I tell y'all that hey, Dolly. Oh, I think that a new trial must be granted. Um, but back to the shots. I dropped an entire bottle of vodka out of my freezer and it exploded like a bomb went off. I have never seen something explode like this before. It shot glass all like I have the weirdest house. It has it's a very old little house and it has a wall going down the entire center of it. And then there's a hallway behind it. And the kitchen is on the complete other side. And it got glass behind that wall all the way at the complete other end of the house, inside a bedroom. Crazy. And yeah, so no, I don't. The moral of that story was no, I don't have shots. But I could do power hour and drink this drink and this drink very quickly if you want. We wouldn't get very far though, since this one's almost gone. Okay. Anywho. The Cameron Court's distinction between the communication being harmless and the subject matter of the communication being harmless and its requirement that a new trial be granted unless the latter is established recognizes that deliberate jury tampering by a court official cannot be cured or excused by the strength of the evidence presented at trial or jurors offering their own subjective opinions regarding their own biases. So this is important. Even if every juror were to testify that he or she would have reached the same verdict regardless of Ms. Hill's tampering, a new trial is required if it is proven that Ms. Hill communicated with jurors about the merits of the evidence presented. Sustaining a conviction based on the court's opinion of the strength of the evidence against the accused, regardless of improper external influences on the jury from court officials about the merits of the case, would effectively be a directed verdict for the prosecution. A statement that whatever happened at trial simply does not matter because the evidence can admit only one result regardless. That would constitute structural error. I don't like, what do you call it? Punctuation. No, I do, but these okay, so then they cite this one case and say, noting that even if the judge certainly reached the right result, a directed verdict against the defendant would be per se reversible, no matter how overwhelming the unfavorable evidence, because the very premise of structural error review is that even convictions reflecting the right result are reversed for the sake of protecting a basic right, emphasis and original. I didn't need to read that. For example, in Parker v. Gladen, a bailiff told a jury in a murder trial that wicked fellow, he is guilty. The Supreme Court of Oregon held that the statement did not require a new trial because it was not shown the statement prejudiced the outcome of the trial. I'm not already drunk. I wish. It would make this easier. Okay. The U.S. Supreme Court reversed, holding the evidence developed against a defendant shall come from the witness stand in a public courtroom where there is full judicial protection of the defendant's right of confrontation, of cross-examination, and of counsel. And we have followed the undeviating rule that the rights of confrontation and cross-examination are among the fundamental requirements of a constitutionally fair trial. Oh, God, this is boring. Sorry, guys. We're going to get through it. We're going to get to the interesting part. Okay, actually, we might just skip to the interesting part. We're not going to skip. We're going to stick with it. In Parker, the state also argued that the bailiff's statement, notice this is a bailiff, not a court clerk, was harmless because 10 members of the jury never heard his statement, and Oregon law at the time allowed a guilty verdict by 10 of, oh, geez. When was that? Y'all, that's crazy. In 66? I wonder if MLS is still here. I wonder if there are any states that allow a guilty verdict with less than unanimous. That's nutty. Okay, so allowed a guilty verdict by 10 affirmative votes of the 12 jurors. I am a lawyer. I just, only know about Texas. Texas. I did see somebody on Twitter did not like my commentary because I don't know all things, but yeah, I don't. Sorry, guys. The Supreme Court rejected that reasoning, and after questioning whether the factual record supported that argument, stated that in any event, petitioner was entitled to be tried by 12, not 9 or even 10 impartial and unprejudiced jurors. That reasoning accords with the reasoning in Cameron 27 years later, the right being protected. No, I'm not. Again, I wish I was. Oh no, this is a, oh, is that what he's doing when he's, I always thought his was no, it's a jewel, man. No. I wouldn't admit to it even if I was, because it's still illegal in Texas. I'm kidding. I'd probably admit to it. I would admit to it, but I'm not. This is just tobacco because I'm yuck. The right being protected is not the right to a correct verdict, but the constitutional right to trial before a fair and impartial jury free from state officials' improper influences. What matters is what was in fact said to the jurors by the state official, not a counterfactual analysis of what probably would have happened had that not in fact been said. Our Supreme Court more recently touched on this point in State v. Green. In Green, during jury deliberations, a juror asked a bailiff what would happen in the event of a deadlock, and he responded the judge would likely give them an Allen charge and ask if they could stay later. The Court of Appeals held that the bailiff's comments were presumptively prejudicial because of his official position. What? But that the state rebutted that presumption by showing for various reasons that the remark did not in fact influence the outcome of the jury's deliberations. The Supreme Court affirmed but modified the decision to correct the Court of Appeals' reasoning. The communication was not prejudicial, not because it did not in fact change the verdict. Instead, it was not prejudicial because the subject matter of the communication was harmless. Yeah. The bailiff's actions here, though improper, did not touch the merits, but dealt only with the procedural question of how the judge might handle a jury impasse that apparently never materialized. Well, yeah, it didn't materialize probably because of what the bailiff said. In other words, a bailiff presuming to tell the jury that if it is deadlocked, the judge will instruct them to keep deliberating is improper but likely harmless because the subject matter is procedural or logistical rather than to the merits of the case. Of course, the allegations in the instant motion that a state official told the jury not to believe the defendant's defense, so bad, or his testimony when he testified in his own defense, indisputably regard the merits of the case. The extensive, deliberate, and self-interested jury tampering in which Miss Hill allegedly engaged far exceeds the simple bailiff mistakes that forced a retrial in Cameron, where a bailiff's misleading response to a juror's question about sentencing options compromised the jury's impartiality because it left the impression that their verdict could not affect the trial court's sentencing direction. Or in Blake by Adams v. Spartanburg General Hospital, where a bailiff told a juror that the trial judge did not like a hung jury and that a hung jury places an extra burden on taxpayers. You shouldn't do that. So this is B. The state misstates the controlling legal standard and provides no authority supporting its mistaken position. In response to Mr. Murdaugh's motion for a new trial, the state incorrectly asserts that Murdaugh must show both the alleged improper communications occurred and that jurors were actually biased as a result. The state can cite no authority supporting that position. The state's response includes citations to several cases purportedly supporting its position, but not one cited case actually supports it. State v. Kelly. The state provides no parenthetical explanation of how Kelly supports its position because the case has nothing to do with the present motion. In Kelly, a juror was accused of misconduct, not a court official. During the guilt phase of a capital trial, a juror provided a pamphlet purportedly expressing God's view on capital punishment to other juries in the jury room. The trial judge dismissed the offending juror, but determined that a mistrial was not warranted because it was not relevant to the issue in the guilt phase of the trial because no other juror had been exposed to the contents of this pamphlet. The Supreme Court affirmed. Chief Justice Finney and Justice Toll dissented. Oh, is this South Carolina? No, because it's Supreme Court, but oh, it is. It is. So they're using Justice Toll, which is, I believe, Justice Toll is going to be the person hearing this actual hearing. Funny. Arguing the inappropriate possession and use of the extraneous pamphlet by jury members so tainted the jury that its contents affected the ability of the jury to be fair and impartial at both the guilt and penalty phases of appellant's bifurcated trial. Regardless, as in the Holmes case that provides the controlling legal standard quoted in Cameron, here there is more than jury misconduct in reading forbidden matter. There was the private communication of the court official to members of the jury, an occurrence which cannot be tolerated if the sanctity of the jury system is to be maintained. When there has been such a communication, a new trial must be granted unless it clearly appears that the subject matter of the communication was harmless and could not have affected the verdict. Holmes. Y'all, do y'all know what? SpaceX. So I just need a little, I need a little breather because I'm sick of reading. But I just thought I would tell y'all that I was living in South Padre during the vid when my girl was just like tiny. And so South Padre is super close to Boca Chica, which is where SpaceX is. Y'all probably don't care about this at all, but I'm telling you anyway. We used to be able to see the rockets taking off all the time, and they would like shake our condo, and it was the coolest thing I've ever seen. I need to go back down there and watch one like in current day because I don't know. I'm afraid to go and watch them because I know they like blow up and stuff. And I think I could be wrong about this, but I feel like they're getting close. Like they keep doing all these test flights down there because aren't they planning on putting people on these rockets? Anybody know? I don't know. But obviously, I don't want to see anything terrible happen with that. So it's also really hard to like time out when to be down there because they'll like set them up and then they, like weather and stuff precludes them taking off that day and then they get postponed forever. And these days I have to work. I can't just like live there. So it's a problem. Okay. Smith v. Phillips. This case says nothing about the standard for granting a new trial when a state official tampers with the jury. So here, Murdaugh's team, yeah, SpaceX is in Texas. Let's go, Brandon. I'm not sure that SpaceX is in Texas. It's like almost in Mexico. It is right outside of where the rockets like take off there's a river and it's the river. But yeah, it's on the beach right there. It's where the river dumps into the beach. Hmm. Okay. Okay, but yeah, this is Murdaugh's team destroying so they're taking all of the cases that the state cited and they're saying why all of those cases were incorrect, right? Okay. So in Smith, the prosecution failed to disclose that a juror had, during trial, applied for employment as an investigator in the prosecutor's office. The U.S. Supreme Court held. This court has long held that the remedy for allegations of juror partiality is a hearing in which the defendant has the opportunity to prove actual bias, and agreed with the state courts and federal district court that no actual bias was proven at the hearing. It reversed the U.S. Court of Appeals for the Second Circuit on the issue of whether the prosecution's failure to disclose the letter was misconduct necessitating a new trial. But the issue in the instant motion is not whether a particular juror had an undisclosed bias or whether the prosecution concealed any pertinent information. I don't know about that, though. I mean, maybe, but I kind of doubt it. Does anybody even know how long did he get for the financial crimes? State v. Green. As explained above, in Green, the court held that an improper procedural comment by a bailiff to a jury was harmless because it did not bear on the merits. There is no suggestion in Green that a comment by a state official that did bear on the merits of the case could also be harmless. 27 years. Okay. And do we know that's in state court, right? It is in state court. I mean, it was in state court. So like it's not a federal case. Oh, but he does have a federal case too, doesn't he? Or does he not? I could be getting that all wrong, but 27 years isn't that bad. I wonder how long. I don't know what, like, the parole situation is there, but I don't know. Seems like maybe there's a possibility he could get out before he, expires. I was watching some, YouTube stream a minute ago, which, like, I should not have been watching, but, um, people are so mean to poor Buster. I really feel sorry for that guy. Just, like, tearing him apart like he's not a victim, which clearly he is. Um, any such assertion would be precluded by the U.S. Supreme Court's holding Parker v. Gladen, discussed above, but notably not mentioned at in the I don't like that. Okay, not mentioned in the state's response, despite also being discussed in Mr. Murdaugh's initial motion. My eyes. The Green Court did reasonably decline to extend the presumption in Rimmer v. United States that any private communication, contact, or tampering with a juror during a trial about the matter pending before the jury is deemed presumptively prejudicial to situations where the communications at issue did not touch the merits of the case on trial. Instead, it reversed the Court of Appeals application of Rimmer prejudice and instead followed the reasoning of Cameron. The inquiry should focus on the subject matter of the improper communication rather than presuming all improper communications are prejudicial and then requiring the state to rebut the presumption even where the communications did not bear on the merits of the case. This has no relevance here because Ms. Hill's alleged statements to jurors indisputably bore on the merits. This is true when you're talking about the defendant on the stand when they were testifying in their own defense, right? What was a Texas case? This wasn't a Texas case, y'all. This was a South Carolina case. Nah, South Carolina. Okay, State v. Cameron. The state cites Cameron for the low country of Texas, so not true. For the unremarkable proposition, not every inappropriate comment by a member of court staff to a juror rises to the level of constitutional error. But in a footnote, claims Mr. Murdaugh's citation to Cameron for the controlling legal standard cite to a portion of the opinion which does not state the legal standard, but rather quotes a portion of a Fourth Circuit Court of Appeals opinion inconsistent with the standard acknowledged by Cameron and more subsequently clarified in Smith and most recently in Green. The assertion only makes sense if the state did not expect the court to read the Cameron opinion. That's not good. The entire portion of the Cameron opinion that follows its factual recitation is quoted below. Oh, lordy, lordy, lordy. Okay. Okay. The trial judge ruled that the jury properly decided that the length of sentence he might impose was not their concern. He further ruled that the short, colloquy between the bailiff and the forelady could not have in any way influenced the jury to refuse to recommend mercy. A defendant in a criminal prosecution is constitutionally guaranteed a fair trial by an impartial jury. And in order to fully safeguard this protection, it is required that the jury render its verdict free from outside influences of whatever kind and nature. The mere fact, however, that some conversation occurred between a juror and a court official would not necessarily prejudice a defendant. In this case, there was the private communication of the court official to members of the jury, an occurrence which cannot be tolerated if the sanctity of the jury system is to be maintained. When there has been such a communication, a new trial must be granted unless it clearly appears that the subject matter of the communication was harmless and could not have affected the verdict. While the trial court adequately instructed the jury on the verdicts of guilty with and without mercy, the jury was obviously confused as to the length of the respective sentences. In this case, the right to fix punishment or make a recommendation that would place punishment in the discretion of the court rested exclusively with the jury. The bailiff's response to the forelady that they should not worry if they were deadlocked because the judge was fair was misleading. It tended to lessen the jury's sense of responsibility by implying that if they rendered a verdict of guilty without mercy, the judge had some discretion in sentencing. Jurors are simply not to consider the opinions of neighbors, officials, or even other juries. The appellant's conviction is reversed and the case is remanded for a new trial, reversed and remanded. There is no standard acknowledged or otherwise stated in the above opinion other than a new trial must be granted unless it clearly appears that the subject matter of the communication was harmless and could not have affected the verdict. Mr. Murdaugh has no idea what Smith case the state believes more subsequently clarified the legal standard. The only Smith case cited in the state's response, Smith v. Phillips. What was that from, y'all? What? Why are we talking crap about Texas? I mean, I'm okay with it, if I'm being honest. God, these are so crazy. Okay. Okay. And as discussed above, Green reversed a Court of Appeals decision to correct its reasoning to bring it in line with Cameron. The applicable standard of proof is a preponderance of the evidence. Y'all, we don't need to go through the standard of proof, do we? No. The court must hold an evidentiary hearing. Yeah, y'all. Hit the like button. Ooh, I'm going to hit some. Can y'all see that? I love those so much. They make me so happy. Okay, yeah. Like, I don't, oh, yay, thank you. I don't know who did that, but I love it. The confetti. Obviously, I don't know who it was. Yeah, the Alamo was stupid. I feel like I probably shouldn't get into that and like say anything about it because I do have to continue to live in Texas, but I would not have done that. I would have run. Okay, the court must hold an evidentiary hearing. The state's response. Thank you, Brandon. Argues Mr. Murdaugh has failed to show. Hey, also, I feel like probably if any of you 25 people are in here, okay, I'm going to resist the urge. Then you've probably already subscribed, but if you have not, please go and subscribe to this channel because I need you to. Please. I know that's annoying, but please do it. Okay. The court appears to have rejected that argument already because it has set dates for the evidentiary hearing. Oh, wait, okay. So the state's response argues Mr. Murdaugh has failed to show that he is entitled to an evidentiary hearing. That's hilarious. The court appears to have rejected that argument already because it has set dates for the evidentiary hearing. Nevertheless, because the state made the argument, Mr. Murdaugh will briefly rebut it. The state correctly argued before the Court of Appeals the standard to suspend the direct appeal and for leave to file a motion for a new trial is a prima facie showing of an entitlement for relief, return to motion to suspend appeal, and for leave to file motion for new trial. And so, like, they're saying they must have already decided that, like, the appellate court, right, already decided that there was a prima facie showing, or otherwise they would not have um, granted leave, right? Yeah, suspended the direct appeal for leave to file the motion. Yeah, you know what else I have? Oh, hi, Great Lakes. Hi, I don't know you. Oh, I do know you. I'm such a dummy. Hi. Did you go subscribe to my channel? Subscribe. I know it's Dave, but I got all excited. It's like my parent is like over here trying to, that was such a dad move and I fell for it. Okay. I got derailed. Oh, no, I know what I was going to tell y'all. I guess that's Dave also. I've really legit never seen this one though. But y'all, guess what I got? Oh, I'm about to like pull my whole new mic and everything down. So that is not a great idea, but oh, can y'all see it? It's not hooked up because I need serious help for that. But I got this thing. It's a Rodecaster, and I have a Stream Deck, which I also don't know how to use. Like, I could be a serious live streamer here if I knew how to work the equipment. And I also have my Shure, what is it called? I don't know, but you know, the big bad boy mic. I don't know how to work any of it. So if anybody knows how to work any of it, give me a call. Anywho. Murdaugh agreed that is the correct standard. In order to obtain leave from this court to move for a new trial based on after discovered evidence, an appellant must make a prima facie showing that a new trial is warranted. Does OnlyFans do streaming? I didn't know that. I mean, I'm not sure what I would be doing on OnlyFans, though. Also, I've never been on OnlyFans, so I don't know. I hear there's like, what is that noise? Y'all, what is that noise? I gotta get out of here or something. Doesn't that sound like I'm getting mail somewhere? Are you? I used to have really cute feet, so I feel like a long time ago, that would have been, like, the way to go. Because I hear that that's, like, a thing there. They're not cute anymore, like, once I got pregnant, yeah, it is Discord, right? How do I get I can't figure out what's happening. Okay, I just closed out of Discord. Okay, thank you, Brenda, thank you. But yeah, ever since I had a kid, my feet are not cute. No, Brandon, I can't even show you. And I haven't had a pedicure in so long. They are disgusting. But they used to be adorable. They're very small. I wear like a size 4 in women's, which is so small. That's also a 2.5 in children's. Just FYI. Okay. The Court of Appeals concluded that standard was satisfied when it granted the motion to suspend the appeal and for leave to file the instant motion. Why do I still hear Discord then? If I just closed it. Oh, Discord's open again? What is happening? What? No, go away, Discord. Oh, that's confusing. And I just watching my my viewers drop. Okay. I gotta stop being distracted. There has been no material change to the law or to the record before the court, other than the discovery of yet more examples of Ms. Hill's dishonesty and malfeasance in office since the Court of Appeals order. It therefore is the law of the case that a prima facie case has been made. The doctrine of the law of the case prohibits issue that have been decided in a prior appeal from being relitigated in the trial court in the same case. Where a prima facie case is made, an evidentiary hearing is required. When the defendant presents a credible allegation of communications or contact between a third party and a juror concerning the matter pending before the jury, the defendant has an entitlement to an evidentiary hearing. The court, therefore, must hold an evidentiary hearing on the merits of the motion for a new trial. Hey, Kayla. How are you? OMG. Y'all, that's crazy. Okay, the state's motions to strike should be denied. In its response, good to see you. In its response to the motion for a new trial, the state moves to strike one affidavits of paralegal Holly Miller. Oh, okay, that makes sense that the state's moving to strike them. Oh, I didn't even see this. Okay. 2, any statements regarding jury deliberations, and 3, any claims regarding y'all have to stop. Any claims regarding Facebook posts, Miss Hill's book deal, or post-trial media interactions. It is unclear what purpose striking anything from the motion for a new trial would accomplish, given that it is the law of the case that a prima facie case has been made, that an evidentiary hearing therefore is required, that an evidentiary hearing has been scheduled, and that the motion will be decided on the evidence presented to the court at the hearing and not on attorney argument made before the court receives any evidence whatsoever. Nevertheless, since the state makes the argument, Mr. Murdaugh will briefly rebut it. First, the affidavits of Holly Miller were offered only as evidence as to what certain jurors would say if called to testify at an evidentiary hearing. Of course, they are hearsay. So this is like totally normal. Okay, cool. Okay, bye, Flash fan. See you later. Thanks for coming. Okay, but this is totally normal, like to get somebody in your office, which Holly Miller worked in Dick Carpootlian's office, and to get them to, do an affidavit to say, this is what I believe this person would say if they were called to testify in situations where you can't get the actual person to come in and sign the affidavit. Then somebody who witnessed it, like a lot of times it'll be like your private investigator or somebody in your office could also do that if they were there to witness the juror recall these incidents. Of course, they are hearsay. All affidavits from persons who have not yet testified in court are hearsay. And then it's just citing Rule 801C and South Carolina Rules of Evidence. Hearsay is a statement other than the one made by the declarant while testifying at the trial or hearing, offered in evidence to prove the truth of the matter asserted. Hearsay is just an objection to the admissibility of evidence. It is not a basis to strike a filing. The purpose of Ms. Miller's affidavits was to help obtain an evidentiary hearing, which has been accomplished. Obviously, they cannot prove Mr. Murdaugh. That's a little bit of a typo, but it's okay. Is entitled to a new trial. Witness testimony in a courtroom will do that. Second, There is no basis for the state's motion to strike references to jury deliberations. Juror 630's affidavit was freely given to support a public filing. Other jurors have spoken about the deliberations in national television interviews. Such statements may or may not be admissible as evidence at the merits evidentiary hearing. But Rule 606 of the South Carolina Rules of Evidence in no way supports striking public statements from a motion memorandum. Third, the state correctly notes that the only relevance of the Facebook post Ms. Hill fabricated to remove Juror 785, her book plans, or her other post-trial actions is to impeach Ms. Hill. The state argues attacking Ms. Hill's character is an outlandish theory against a dedicated public servant. That is immaterial, impertinent, and scandalous, and so should be struck. That is incorrect. Ms. Hill likely is the only witness the state can offer who can directly contradict Juror 630's avertment of jury tampering, and Ms. Hill has offered an affidavit doing exactly that. Respondent opposition motion for new trial, Exhibit A. Her credibility is the clou of the matter before the court. The purpose of the evidentiary hearing is to allow the court to decide whether it believes the word of Ms. Hill more than it believes the sworn testimony of one or more jurors. Anything that impeaches Ms. Hill is relevant. And the state's rhetoric about Ms. Hill being a dedicated public servant, unfairly maligned, has not aged well in the 2 months since the state filed its response, to put it mildly. Hilarious. Such a burn. So true. What? That's hilarious. Ms. Hill is alleged to have stolen money, illegally sold access to the courthouse, conspired with her son to conduct illegal wiretaps, and even had her book removed from publication because of her plagiarism. Oh my God, it looks so bad. To prevail, Mr. Murdaugh must prove by a preponderance of the evidence that Ms. Hill made statements to at least one deliberating juror about the merits of the evidence presented at trial. So I was watching, I don't remember what I was watching the other day, yesterday specifically, and I saw, oh, what is her name? Anjanette Levy, is that her name? Somebody from like Court TV or Law and Crime or something like that. And she was actually saying that like everybody, the media, all knew that she was having conversations with the what do you call it? There we go. Thank you. Having conversations with the foreman because at that party that Becky Hill hosted the night before sentencing, I think. So maybe was it the night before sentencing or was it the night before closing arguments? Regardless, she was there bragging about the conversations that she was having with, uh-oh. I need to delete some stuff from StreamYard. But she was bragging about the conversations that she was having with the foreman, and apparently all the media outlets, or at least Levy, was trying before sentencing. Okay, thank you. Airdrie. I'm probably saying that wrong because, reading, not my thing. But thank you. Before sentencing, yeah. Okay, cool. They were trying to confirm that this had taken place, but apparently couldn't get confirmation. But like they've known for that long. That's crazy to me. Nobody said it at the time, I guess, like because they were doing their job and not just reporting rumors, but apparently she was going around bragging about it. That is nutty. Okay. The issue presented to the court is not what happened during deliberations. Hey, Jung. Hey. It is what happened during the presentation of evidence at trial. Mr. Murdaugh anticipates at least one deliberating juror will testify that Ms. Hill advocated against Mr. Murdaugh in improper communications to jurors during trial. That's so bad. And that at least two other persons who were part of the jury at the time will corroborate that testimony. Such communications include telling jurors not to be misled by evidence presented in Mr. Murdaugh's defense and not to be fooled by Mr. Murdaugh's testimony in his own defense. Based on the chart of juror interviews provided in the state's response to the motion for a new trial, at least 5 jurors, including the dismissed juror and alternate, will testify that Ms. Hill told jurors to watch Mr. Murdaugh's body language when he testified. That is so wrong. And she talks about it all through her book about his body language and how she knows from all her experience in the courtroom, she can tell when somebody's lying, which no, she can't. Just no, she can't. Otherwise, she would have done a better job of concealing her own lies. Mr. Murdaugh also anticipates juror testimony that Ms. Hill asked jurors for their opinions about Mr. Murdaugh's guilt or innocence, that she pressured jurors to reach a quick verdict, telling them from the outset of their deliberations that it shouldn't take them long. And she actually had an email to someone that I noticed that she was telling the media, like they were asking about it possibly going on towards the weekend. And before they even started deliberating, she was telling the media it shouldn't take that long. I anticipate them coming back before then. We have a good jury. Yes, she is a body language expert as well. Who knew, right? And that she had frequent private conversations with the jury foreperson. It is likely several jurors will testify that they never heard any such jury tampering and that they do not believe it occurred. But that is not a direct contradiction of the testimony of jurors who say they saw and heard it. This is true. Mr. Murdaugh anticipates the only person who can directly contradict jurors who witnessed Miss Hill's jury tampering is Miss Hill. Mr. Murdaugh, therefore, must present evidence corroborating Juror 630's testimony, including testimony from the alternate jurors and Juror 785, who was dismissed on the last day of trial, and possibly testimony from court staff. He must also present evidence impeaching Miss Hill. Evidence impeaching Miss Hill includes her emails, text messages, and telephone records, testimony from court staff, testimony and documentary evidence from persons involved in the production of her book, complaints against Ms. Hill, and the results of investigations into Ms. Hill's wrongdoing. It includes evidence related to her involvement in the removal of Juror 785, not because the removal itself is grounds for a new trial, but because Juror 785 has, I don't even know what that word is, averred. Ms. Hill was involved with her removal in an improper and dishonest way that, if true, would serve to impeach Ms. Hill's credibility. Both witnesses and documentary evidence regarding the allegedly fabricated Facebook post, which ultimately did not cause Juror 785 to be removed, and witnesses and documentary evidence regarding Juror 785's alleged statements to her tenants during trial, which ultimately did cause Juror 785 to be removed, are relevant to Ms. Hill's credibility. Evidence impeaching Ms. Hill includes evidence demonstrating her personal interest in the outcome of the trial and willingness to engage in obviously inappropriate conduct to further that personal interest. For example, emails related to journalists in response to FOIA requests show that Ms. Hill was sending emails directly to prosecutors and law enforcement witnesses for the state during trial about the merits of testimony from defense witnesses under examination at that moment. Emails from B. Hill to C. Waters, C. Jewell, and C. Gent. Attached is Exhibit A. Evidence impeaching Ms. Hill likely also includes testimony from Judge Newman. It is possible that Ms. Hill will respond to one or more questions at the evidentiary hearing by asserting rights under the Fifth Amendment. She should not be permitted to do so. She waived the right to assert the Fifth Amendment in this proceeding when she submitted an affidavit specifically denying each allegation against her. See Brown v. United States, holding that if a witness offers testimony voluntarily, his credibility may be impeached and his testimony assailed like that of any other witness, and the breadth of his waiver is determined by the scope of the relevant cross-examination. If she asserts the Fifth Amendment in response to any question, she should be instructed to answer the question. If she refuses, her testimony should be struck in its entirety. Right. And her testimony, I think, would also include the actual affidavit that she submitted where she denied each allegation against her, right? There will be much evidence to present that impeaches Miss Hill. The state may argue presenting it all would be cumulative or repetitive or otherwise unnecessary, but evidence is cumulative only when it supports a fact established by the existing evidence. They're just citing Black's Law Dictionary. So long as the court is prepared to give Miss Hill's testimony any weight, her lack of credibility is not established, and evidence impeaching her cannot be considered cumulative or repetitive. Courts have underscored the non-cumulative nature of additional evidence when a trial features a swearing match between witnesses on both sides. That's just like a bunch of case law. I don't care. But let's read this little note. If the court were to decide pre-hearing that it cannot credit Ms. Hill over the sworn testimony of any juror, it is likely that the hearing would consist only of court-conducted in-camera examination of jurors. This would also avoid potential Fifth Amendment issues regarding Ms. Hill. It is unlikely the state would agree to that, since it is likely the state can prevail only if the court finds Ms. Hill to be credible. Well, this is true. Currently, defense counsel anticipates identifying the trial transcript and exhibits from trial for use at the evidentiary hearing. However, until such time as the state provides Mr. Murdaugh with its discovery in this matter, his counsel is unable to provide the court with a complete list of exhibits and witnesses or a list of subpoenas he needs. Once the state produces its discovery, defense counsel will supplement this response immediately to provide a complete list, including a list of subpoenas he needs, if any are needed. It is likely much of the information he would otherwise seek by subpoena has already been compiled by the state. To the extent more subpoenas are needed, it would expedite the process if the court were to authorize Mr. Murdaugh's counsel to issue subpoenas ducis tecum. That means returnable before the evidentiary hearing, or depending on the recipient, to issue the requested subpoenas itself. So those subpoena ducis tecum are for documents. So it's like you subpoena somebody to bring in the documents. Mr. Murdaugh at present does not anticipate requesting subpoena for documentary discovery regarding any deliberating juror, but cannot be certain before receiving discovery from the state. Okay, bye, Airdrie. Oh, okay. I mean, I get it. I get it. I mean, I really only get it if Taylor Swift is there, but and she's not, right? The state had months in which to Thank you. Okay. The state had months in which to use the tools available to law enforcement to conduct discovery regarding this motion, as well as to investigate the numerous independent complaints of wrongdoing against Ms. Hill. It will be well prepared to bolster its witnesses and to impeach witnesses favorable to the defense. Mr. Murdaugh has been unable to conduct any discovery whatsoever. All he has are voluntary statements made by jurors and other witnesses willing to talk to his lawyers and information published by journalists to be prepared to go forward on the January 29th date set for the evidentiary hearing. He urgently needs the state to produce its discovery and to receive authorization to issue his own subpoenas as soon as possible. Okay. G. Jurors and Judge Newman, if necessary, should be examined in camera by the court, but other witnesses should be examined by counsel in open court. So when you're examined in camera, that just means you're examined, like, you're only examined by the court. So the counsel for the state or for the defense would not be asking the questions. It would be the judge that would be asking the questions of the witnesses, right? Or of the witnesses, which could also include Judge Newman if necessary. The default method of examining witnesses at an adversarial proceeding is through questioning by counsel for the parties. When required by the interest of justice only, the court may interrogate witnesses. Okay, so that's just saying the court may interrogate the witnesses, so that, instead of counsel. All witnesses should be so examined unless there is good cause to reserve examination to the court. Mr. Murdaugh believes good cause exists for the court to conduct the examination of jurors, including the dismissed juror and alternate juror itself in camera with a redacted transcript provided to the public. This makes sense to me. In addition to asking its own questions, the court could accept suggested questions from the parties in advance of the examination and during the examination, which the court in its discretion may or may not ask. In addition to shielding jurors from appearing on television involuntarily, in-camera examination is necessary because it will be difficult for a juror to testify without revealing personally identifying information like his or her name or the names of other jurors. By testifying in camera, jurors may speak freely, with any personal information in their testimony redacted from the publicly available transcript. Further, jurors may be unsettled by being interrogated by the same lawyers they watched interrogate witnesses for 6 weeks. Examination by the court avoids that issue. I agree with this wholeheartedly, especially as a defense attorney, because a lot of times the jurors are not going to at all be comfortable having you interrogate them. The state agrees jurors should be examined by the court and has argued the court should question them with a mind to at least 1, whether the communication actually occurred, and if so, its context and substance. 2, the number of jurors exposed to the improper communication. 3, the weight of the evidence properly before the jury. And 4, the likelihood that curative measures were effective in reducing the prejudice. Okay, so the state has already agreed to that, I guess. And that's the respondent's opposition motion for a new trial. Only the first topic is appropriate. The only relevant subject for jury examination is whether Ms. Hill made improper communications on the merits of the case, including anything serving to corroborate or refute testimony on that subject. The number of jurors exposed to the communication is irrelevant so long as it is at least 1 deliberating juror. See Parker. The weight of the evidence properly before the jury and the likelihood that curative measures were effective in reducing the prejudice are entirely irrelevant under the controlling legal standards, see Cameron, and appear to solicit testimony inadmissible under Rule 606B of the South Carolina Rules of Evidence. If testimony is needed from Judge Newman, Mr. Murdaugh believes it should also be conducted by the court in camera to preserve the dignity of his judicial office. That was very nice. Mr. Murdaugh does not believe good cause exists to examine any other witnesses, including Ms. Hill, in any fashion other than the traditional means of attorney questioning in open court. Ms. Hill especially is an elected public official accused of malfeasance in office, whom Mr. Murdaugh has accused of violating his constitutional rights in a criminal proceeding and who has voluntarily provided an affidavit directly contradicting Mr. Murdaugh's claims. She does not need to be shielded from scrutiny in the same manner as anonymous jurors involuntarily summoned to serve. She is a witness against Mr. Murdaugh in a criminal case whom Mr. Murdaugh has a right to challenge in open court. This is true. Oh, no. Did you make the cable man mad? I mean, I feel like I should know this, but I don't. But isn't Lebowski the oh, what's that dude's name? The the dude, the Big Lebowski? The Bud Lebowski. I don't get it. But I feel like at least I'm like, I don't know. Okay, so this note says, additionally, although the Sixth Amendment confrontation clause does not apply to a motion for a new trial, the United States v. Boyd, Article 1, Section 14 of the South Carolina Constitution provides that, see, I don't know what any of this means, except maybe this is from that movie, and I'm just not getting it. What? Y'all, I don't know. Okay. Okay, any person charged with an offense shall enjoy the right to be fully heard in his defense by himself or by his counsel. The right would be violated if the court were to credit Ms. Hill's testimony against Mr. Murdaugh without allowing his counsel the opportunity to challenge her testimony through cross-examination. My throat just hurts too much to continue this. If the court were to decide that Ms. Hill's testimony cannot be credited, her testimony would not be relevant to any issue that Mr. Murdaugh would have no right to examine. And Mr. Murdaugh would have no right to examine her. H. Here's where we get to, I guess I should. It's the Big Lebowski. Okay. Okay, so counsel for non-parties should not be permitted to participate in the proceedings. So this is where we get to attorney Eric Bland, who just seems like blah, blah. If I'm being honest, that's how I feel. Attorney Eric Bland has requested to participate in these proceedings as counsel for certain jurors who may be called to testify as witnesses. Mr. Murdaugh objects to Mr. Bland's request. This is a criminal proceeding brought by the state against the defendant. Mr. Bland seeks a level of non-party participation, e.g. participating in status conferences, beyond even the rights afforded victims under Article 1, Section 24 of the South Carolina Constitution. And the jurors he represents are not crime victims. This is true. In discussing his request in the media, Mr. Bland stated on his podcast, Cup of Justice, oh, that's his podcast? I've never heard it, but I've seen it like a bunch. Episode 61, December 26, 2023, that Justice Toll, the newly assigned presiding judge in this matter, has friends sometimes to reward and enemies to punish. Ooh, that's not good. And I worry about what procedures are going to be put in place. The fact that there was a status conference, and I represent 4 jurors, and I wasn't even told of that status conference. And I believe that my jurors have the right to legal representation in any type of proceeding dealing with Alex Murdaugh's verdicts. Oh, please. Where they're going to have their verdicts questioned. His stated intent is not to protect the personal interest of his clients as witnesses, but to advocate to sustain their verdict. To allow a publicity-seeking lawyer for non-victim private parties to intervene in this criminal case and advocate against Mr. Murdaugh is an additional opposing party would violate Mr. Murdaugh's procedural due process rights under Article 1, Section 3 of the South Carolina Constitution and the 14th Amendment to the United States Constitution. The jurors are simply witnesses with no more right to participate in this criminal proceeding than witnesses in any other criminal case. Unlike typical witnesses, they do have a right to a degree of anonymity So it could be appropriate to allow them to be heard through counsel if the court were inclined to strip them of that anonymity. But neither party is asking the court to do that, and the court has made clear it is not inclined to do that. Mr. Murdaugh does not seek to subpoena telephone records or other personal records regarding them. And if he decided to do so in the future, their lawyers, of course, could move to quash the subpoena. Otherwise, they have no cognizable, oh man, how do you say that word? Cognizable interest in these proceedings. And if there is such an interest, the Attorney General would be adequate to assert it. Makes sense. The reason to hold an evidentiary hearing on defendant's motion for a new trial is to protect Mr. Murdaugh's constitutional right to a fair judicial proceeding. It would defeat that purpose if the proceeding were allowed to devolve into a speaker's corner for lawyers who want to appear on television even more than they already do. Mr. Murdaugh therefore asks the court to limit the participation of any witness retained lawyer to the extremely limited role traditionally allowed to a lawyer representing an innocent bystander witness in a criminal case. So, like when an attorney says, hey, you need to plead the fifth, you know. Further, he requests that the court order the clerk of court not to accept any filings in this matter from any non-parties without leave of the court obtained prior to filing. Conclusion. For the foregoing reason, Mr. Murdaugh respectfully submits that when Ms. Hill's jury tampering is proven at the evidentiary hearing, the court must grant the motion for a new trial. Boom. Okay, so yesterday I did I went on with Excited Utterance, and she actually had the exhibit to this filing, and the exhibits were actually emails that we have already gone over regarding that witness that was on the stand, the defense witness that was on the stand. I don't remember his name at the moment, but he was testifying about how tall the shooter had to have been, and it was emails that went to the clerk of court where he sent those, where she then forwarded those emails on to Creighton Waters or to his paralegal. And yeah, that's like so not cool. We've talked about it before. At least we talked about it yesterday in Excited Utterance. I don't know if I've actually stated what the options would have been, but she should have taken those emails to the court. So that being Judge Newman. And I think Judge Newman would have told her, that she needed to she needed to make those emails a part of the record, or she needed to forward them to all parties. So also to the defense, right? If she was going to forward them to the state, she needed to also, or to the Attorney General's office, she also needed to forward them to the defense, but she did not. Or I think that he might have told her to ignore them. It seems like in other email communications that we have in this case, you think I'm wildly inappropriate? Did I say wildly inappropriate? Did I use that word? That's amazing, because that's not even like something that I would normally use. That means I'm becoming a real streamer. I'm starting to say things I don't even use in real life. Maybe I am wildly inappropriate. I don't know. But yeah, I think that he would have said that she needed to ignore them. That's really what I think he would have done, because he ignored plenty of things in the trial when strange things were brought to his attention. But otherwise, I think he would have made it a part of the record, just like he made other things a part of the record. And yeah. Order in the court. Y'all, I want a gavel. Whoa, look at that light under my arm. Anyway, yeah, I want a gavel so I can smack my desk. I also need another desk because y'all know I have this new microphone and my thing, it's like my desk is like this thick because it's like a makeup desk. It has like these giant drawers in it that have all my makeup in it. And so I can't like hook the strangest thing I think Dave has in his treehouse. I think that he sometimes oh yeah, besides the corpse. I think he has chickens up there sometimes. He hasn't told us that, but like I've heard them. So I know he's probably torturing chickens up there. Speaking of which, I heard that like everybody is aware of the fact that there are new ducklings, which I have not seen in person. Has anyone seen them? I'm going to need you to comment. If you've seen them, comment. If you've heard them, comment. I've heard about them, but I've not seen them. Has anyone named them? Also, I haven't seen Val in like since way before Christmas. How do you know? When I started the stream today, I played Feeding the Ducks again as the music. Hmm. I will. I will. I will. Are you still out in Bandera? Are you back in the ATX? I know you're not actually in ATX, but like closer than Bandera, I believe. Oh, you don't? Yes, Dave. Hey, does anybody know if this is our Dave, like MLS Dave, or is this a different Dave? I feel like it's a different Dave. I don't know. But, oh, hi. What time is it in Australia? What issue? You don't know what time it is in Australia? That's interesting, Dave. I know I'm not supposed to preen on stream or whatever it's called, but my lips were looking dry. So, I do what I have to do and I don't care. I don't care. Brandon. I mean, that's not MLS because that's not his thing. But that's the map. And where does the map come from? That's either the not Biden or not Obama or something, or I don't think it's Brandon. I thought it was Brandon for like a half second, but I don't think it is. But I remember somebody had a map. Okay. Well, so we have devolved into debauchery. It appears. It appears. Anyway, I don't think that I was gonna go over some emails with you guys, but I feel we're not up for it, guys. We are not up for it. Oh, is there? Is it the clerk of court? Well, there could be very soon, right? I wonder how much they get paid. Yeah, I was also gonna go over parts of this book, but the book is just so bad. Don't buy it. Nobody buy it. It's just terrible. And there was like no new information in it. Nothing new. All right, guys. Well, I don't know if anybody paid any attention to the Caitlin Armstrong trial, which is like basically the first trial I did on here. Um, like that I did seriously. There is a new filing in her case, and it is the motion for new trial, and it specifically alleges like new evidence, and it's regarding the rebuttal witness from the state on the DNA, the stuff about whether or not it was transfer or not. But then it also talks lots of smack about her defense attorneys and ineffective assistance of counsel, which I might have said a thing or two about that during the actual trial. I mean, I didn't like straight up say, hey, they were ineffective, but like I definitely mentioned the fact that they put on no mitigation evidence. Yes. And Christine, well, she didn't have a baby, but they definitely also said that they said that she was pregnant twice, and the last time she was pregnant in like around the time of the offense, which to me, yeah, that should have been put on during mitigation, but definitely the sister had so much more to say than she actually said on the stand, and like she can't just say whatever she wants on the stand. She is being questioned. So that was kind of the defense attorney's fault if she didn't get to where they needed her to get, right? And so yeah, that's their problem. But it definitely says she was pregnant, but it also, yeah, it has a lot of good stuff in there about her. And yes, oh man, I always click the wrong one. But yes, Dave, this is true. It is always fraught with difficulty, least of which is like it should have actually been known to. Well, there were a lot of issues with the defense at the time. Like, no, I don't think that she will get a new trial. But I do think that it's possible that she could get a new no, I don't think she'll get, like, an entirely new trial. I think it's possible that I think the stronger argument is for her to get a new sentencing trial hearing because, because they put up no defense whatsoever. I mean, their job is to mitigate during that portion of the trial, and they did none of that, like, none of that. I've read on Reddit, though, where, like, some people who attended the trial are like, "Oh, her defense attorneys were awesome." They just were not. Like, they were not. Um, I said throughout the trial that they are former prosecutors. They have not tried any cases as defense attorneys. I stand by that. I think the lead attorney tried one case before this case as a defense attorney, and it was a misdemeanor. This is obviously a felony case with like the max punishment. I mean, besides the option of the death penalty was not on the table. So it wasn't a capital case, but it was obviously up to life in prison, and she got 90 years. And that is like the longest amount of time that I've seen in Travis County ever. And I've been doing this in Travis County for what, 12 years now? Or maybe 11 years, 11 and a half years, I think. Um, but yeah, a really, really long time. I don't think they necessarily did their job all the way. Interestingly enough, one of them is now running for district attorney and will possibly win. He is obviously a former prosecutor, and then there is another prosecutor. So, like, the issue in Travis County right now, I don't know if anybody has like read anything about it, but I don't even know what that guy's name is. But the one that like all the conservative people say puts like all these DAs in power. If anybody knows what I'm talking about, put it in the chat. But like conservatives always say, like, oh, it's a blank blank DA. Some media guy or something that like contributes to a bunch of DAs winning. Does anybody know what I'm talking about? Anyway, this DA in Travis County is one that, like all over the nation, they say is one of those people. And Travis County is an incredibly blue county, even though we are in Texas, which is very red. Travis County, oddly enough, is very blue. And while we usually like always have, I mean, I don't even know the last time that a Republican, or if it's ever even happened that a Republican won, or it was a DA. The last time that we had this election in Travis County, we had like a super left leaning. Hey, thank you, Lizzie. We had a super left leaning. Okay, so this is Brandon. Brandon, go back to your normal one. Anyway, a super left-leaning DA. Yeah, dude, you're giving yourself away, Brandon. Go back to Let's Go Brandon. Because you're under MLS making law simple right now. And I was trying to claim that you were the Obama guy. I don't ever see the Obama guy anymore, but I guess that's because he doesn't ever come to my chat. He only went to Val's chat. That makes sense. Anywho, but now there is a Republican running for district attorney, and in my opinion, even though I have run for public office before in Travis County, long story, and I did run as a Democrat, long story. My opinion, the person running, so there's going to be two people, I believe, running as Democrats, one of those being one of Caitlin Armstrong's defense attorneys, one being the current DA in Travis County. And then there's going to be one Republican running. and his name is Daniel Betts. And if anybody out there is watching and you are a voter in Travis County, I would advise you to look into him. He is a criminal defense attorney, and he's like always been a criminal defense attorney. And he does try cases, and he is extremely knowledgeable, and he is like the best bet. So there's that. I did run for office once. I ran for judge. And like, yeah, I am gonna do live streams of trials. Maybe. I don't know. I did them with Val, and they were like, they took forever. Getting monetized. I don't know. Like, I don't know the difference between getting monetized and just like being able to get super chats, but I'm like 40 or a little less, I think, than 40 subscribers away from the 500 that I have to have in order to, and like, I'm not sure how many hours I have of live streaming, or not live streaming, but like watch hours. Um, it's the wrong one. But I think I'm kind of close to the watch hours, which I think are 3,000 watch hours. And I don't know, I haven't checked in a while, but I know I still need like 40 more subscribers or something. I know we do need more content. And I'm like shocked that I wasn't super scared of live streaming today, because normally I am so, so scared. But today was fine. So maybe I'll just do some more lives. You should. And then you should put it on my channel. Like, so, I don't know if y'all ever watch, like, I'm not drunk. I don't know if y'all ever watch, okay, so I have a guilty pleasure, and it's watching, what is it called? Dad Challenge Podcast, I think. And anyway, so I know I've mentioned it before. I'm a single mom. I don't know how many times I'm gonna mention that, but like, I've always been a single mom. I was a single mom by choice. I went into this with the intentions of having a child on my own because I was 35 and I wanted a child, and I had no, like, I wasn't dating anybody, there was nobody. I didn't plan on having a child with anybody at that point in time, and I'd like, always made a promise to myself, if if I didn't have anybody in my life at 35, I was just gonna like, "Hey, Baker." What? Oh, well, that's understandable. So, anyway, during the, pandemic, my dad was like, I had this little baby, and my dad was like just kind of discovering YouTube, I think. And he was like, "Oh, McKinley, like, you should start like a mom channel, you have this little baby, and she's like the prettiest thing I've ever seen in my whole life." Because my parents are like super biased. And they literally think she's the prettiest thing they've ever seen in their whole life. And they were like, "Oh, you should just start putting her on camera." And so I actually, this is crazy, but I actually like got this camera with the intention of, and my daughter is also, now she's 4, and she's like very into YouTube, because again, single mom. Like, she needs to stay entertained, and she's like very into YouTube and all the like kid YouTube channels. And so she has like, she calls this camera that you're looking through right now, she calls it her vloggy, that she's gonna make vlogs with. But anyway, I don't even know where I was going with that. Oh, I know. You said get a lot of views. So yeah. Anyway, I started watching Dad Challenge podcast, and I was like, oh, he's like very anti putting your kids on the internet. And like, sometimes it's impossible for me to keep her out of here. Like, I try to keep her out of here if she's with my parents. Obviously, that's one thing. But like, when she comes home, if I'm on stream and she comes in, then y'all just see her. And that's just, that is what it is. But it's, at least it's not like her own channel. I'm not like putting her on there in her little like bathing suit or her little leotard and like asking all the pervs to come and watch her. But she did do something so cute yesterday. She made me get this camera off of the tripod and take it outside so that she could rollerblade for her vloggy. And she made me record it. And I was like so thinking about putting it up on my channel, but I was like, oh man, that'd be one way to get those other 40 subscribers. But I'm not that evil of a mom, and I'm not gonna put her out there for the perv. I mean, but they did get millions of dollars, right? Just kidding. I mean, I think that so if you're gonna go the 8 passengers route, I think, like, you also have to be, like, the evil mom that would do that to your children, right? And I would just never. I would just never. I know that there's, like, plenty of people who still believe in, like, I don't wanna say corporal punishment, but, like, spankings and stuff. And I've recently started to say to my daughter, like, "Oh, you're gonna get a spanking," like, it doesn't phase her at all because she knows she's never gonna get a spanking, she's never had a spanking, and, yeah, I just don't believe in hitting. So, I definitely don't believe in tying children up and kicking them with your boots and making them jump in cactus and, or cacti. Is it cacti? Cactus? Cactuses? Cac Who knows? But, yeah, I'm not into that, or, like, depriving them of food and water. I mean, I might deprive my child of food and water sometimes, but not intentionally, just because I don't cook. Yeah, do you think that they're really going to go for 60 years? I don't know. I find that to be, like, a bit much. I'm not saying she doesn't deserve it, I just think that that's, like I don't know, I just think that that's a lot. Of course, I'm a defense attorney, but, I mean, I find, like, nothing to defend in their, like, uh, child abuse is super hard for me. I can't defend those kind of cases. I don't even like to cover those kind of cases, I've decided recently. But, the 8 passengers case is odd. Yeah. Honestly, I would have rolled the dice in court. Like, I would have rolled the dice if my only options were because it does seem like I mean, there was no agreement as to, like, the max on in her plea, right? Yeah, I was, like, a little stunned that she decided to, go ahead with it. I don't know. I don't understand it, but yeah, I wouldn't have I don't want 60 years. Oh, Baker. I wish you had a link. I'm gonna have to send you one next time. I didn't know you were awake. What time is it right now? Wait, what did she do at age 43? Oh, like the single mom thing? That warms my heart. It is so hard. Like, so many of my family members, I guess, told me this, like, "Oh, you have no idea what you're doing. It's gonna be so crazy hard," and it's, like, way crazy hard. I also didn't realize that, like oh, yeah, okay. I don't need to send you links. I don't know what 2320 means. What? So it's nighttime. Yeah, it's nighttime. Oh, okay, you need to go to bed. You need to go to bed. But yeah, Lizzie, super hard. Did she already had her baby? They're so much easier when they're kids too, but I mean, when they're infants, but, like, the craziest thing is they start to ask about their dad, like, as soon as they can talk. It is crazy. As soon as she started school around all these other kids that, obviously have dads coming in every day, she immediately started asking about her dad, and it just gets worse with, like, each, like, 4-month period that we go through. Last Christmas was super hard. She was very angry. But, you know, what are you gonna do? What can you do? But yeah, that's awesome, Lizzie. Oh, I know, right? Well, I'm getting off, but I will turn them off. I did see how to do that actually in my mastermind. My, what's that dude? The lead attorney mastermind. They did it for the last one. So I will do that after I get off of here, but I don't actually know how to do all of those things, so I'll have to go look it up. But I didn't know you were live, Sal. But anyway, I will try to like put out more content going forward. If y'all comment after this, like if you get on and you make a little comment under the live on YouTube and tell me like what cases you're interested in that are current right now that we're not like too far behind on. I know a lot of people said we're behind on this one, but it's not true because I like was very invested in this case. So I actually know what's going on in it. And I feel totally qualified to comment on it. Oh, oh, colic. Oh, God. Oh, but see, I think it's so much easier going like at 24. Okay, well, maybe that's why it was so hard. I can't imagine going through that at 24. It was so easy. Having a newborn child was the easiest thing ever. Like, it was so easy and wonderful, and it felt like Christmas every day of my life until she started talking. But luckily, she was, like, a very late talker. She was, like, over 2 years old, so we had some great years there. But, yeah, go into my comments and comment about what cases you wanna talk about next, and we will do it. I know that there is a hearing coming up on the 16th, and then there's, like, another one starting on the 29th, and, I think I'm going to be stopping by, Excited Utterance for at least one of those, but let me know what y'all want to cover, and we will cover it, okay? Go to sleep, Baker. Goodbye, Flash fan. Bye, everyone. Oh, that's terrible. That is not much time to enjoy. Okay. Bye. See y'all next time.